When one party buys or leases real property from another, the two parties often make subsidiary agreements. Do these side agreements bind the parties' successors in interest, or are they personal to the contracting parties? That typically depends on whether the agreements touch and concern the land. Some agreements, such as a promise to maintain an easement, clearly touch and concern the land. Therefore, assuming all other requirements are met, they run with the land, binding future grantees. However, not every case is that simple, as seen in Mullendore Theatres versus Growth Realty Investors. In 1969, Connor Theatres entered a 10-year lease. The lease required Connor to pay a security deposit of $22,500. The lease provided that if Connor were to default on its lease obligations, the landlord would be entitled to use the deposit to cover any damages caused by Connor's default. If Connor didn't default, the deposit would be returned at the end of the lease term in 1979. The lease also stated that all covenants in the lease would run with the land. Connor later assigned its interest in the lease to Mullendore Theatres. At that time, the deposit was reduced to $6,000. Growth Realty Investors Company acquired the property from the original landlord. Growth Realty then resold the property to the city of Tacoma. The city was concerned about the potential $6,000 liability, so Growth Realty agreed to indemnify the city for any liability from the deposit. In 1980, Mullendore negotiated a new lease with the city. As a term of the new lease, it released any potential claims against the city for the return of the security deposit, but reserved such claims against other parties. Mullendore then sued Growth Realty for the return of the deposit. The trial court ruled for Mullendore, holding that the covenant ran with the land. Growth Realty was thus bound by the indemnification clause in its purchase contract with the city. Growth Realty appealed to the Washington Court of Appeals.